presented before you, and the applicants have come before you under Article 51, Sub-Article 2, on the right of habeas corpus. Habeas corpus, my lord, and I want to submit strongly that under Article 25 is one of the non-derogable rights. Equally, the right to be heard is non-derogable, and therefore we are at an equal pedestal when we are exercising our rights. Rather, these applicants are beseeching you to exercise your discretion, set aside the orders, or stay the very best your orders. Grant us that limited time to be heard as provided under Article 50. And then, during the inter partes hearing, this court will make an informed decision on how to sustain those orders or even to vary them so that each party is put at an equal footing. And these orders, my lord, are discretionary, are in the interest of justice. And I have said, my lord, equally, the respondent will feel, and I support what Mr. Nyamodi says. For example, if you look at Article 22, and of course the court has sat in several matters of this nature, orders of habeas corpus under Article 51, Sub-Article 2, are orders granted where the applicant is in custody, lawful or not in a lawful custody, such that he is produced in court. If, for example, my lord does not exercise that discretion to just take those orders and hear the parties on the allegations that have been made before them, then ultimately the parties will be condemned unheard. And what the respondents are just craving for is setting aside and listening to us, inter partes, so that we make an informed decision. Because habeas corpus, by very nature and how they are crafted, they are final orders. And they can never be a fishing expedition to just look for evidence on the assumption that the respondents are holding. And I think I will rest my case at that point, my lord. And
so you've been, now that forces me to intervene and ask a question.
Yes, my lord.
I've been restraining myself, and now it's like I have to ask you a question. The applicants or the petitioners come before the court and say what they say, right? Now, you are here urging us to set aside those orders. We will consider that. And you must have heard me ask Mr. Nyamodi, I'm not doing their case, but now I have to ask you the question. When you say you want an opportunity to be heard, and I've read the affidavit, what is the applicant's case? Because you are supposed to lay before the court a basis for setting aside the orders. All right? What have they said is their defense? Have you looked at their, you must have seen their application, you must have seen their affidavit. And you heard me, and that's why I had to record Mr. Nyamodi verbatim. He has instructions that they have a defense.
My lord,
So those are the things I was avoiding to go into. And here, as you rightly say, habeas corpus by its nature, yes, is a very serious matter.
Yes, my lord, I agree with you.
It's a very serious matter that we cannot just look at and say, oh, this or that. So the issue you are saying, I hear you, but I'll make myself, I don't want to say much, Minister.
I get the concerns of the court.
Let me leave it there.
Yes, most of it.
Thank you. So you urge that the application be allowed?
Yes, my lord.
The respondent, the petitioners, who is going?
Yes, my lord. For the petitioners, we are asking for just 15 minutes.
I'll give you 10. I gave him 10. I know he went beyond the 10. I'll give you 10 formally.
I'm very grateful.
Sorry?
I'm very grateful for this.
So I'm giving you 10 officially, but I will allow depending on the situation.
Okay, my lord. But first,
so you oppose the application?
Yes, my lord. We oppose the application. We have since filed, and we rely on our replying affidavits sworn on the 16th, which has also been served on all the respondents.
I have a copy. Give me a minute.
Okay, my lord.
Ni mahakama ya Milimani, familia, mawakili na majaji wakiwa katika mahakama hiyo wakiendeleza kesi hiyo ambayo ni wale jamaa wanne wa kule Mlolongo ambao walitekwa nyara tarehe 17 Disemba mwaka uliopita, na hadi kufikia sasa hawajabainika wako wapi na hawajawasilishwa katika mahakama hii. Mahakama hii ilikuwa imeagiza Inspector General wa polisi Douglas Kanja na mkuu wa idara ya upelelezi nchini Mohamed Amin kufika mahakamani kuelezea walipo wanne hao na iwapo wanajua walipo na iwapo kuna chochote ambacho kinaendelezwa na maafisa wa polisi ili kubaini walipo. Lakini hadi kufikia leo, ikiwa ni takriban mara ya 3 wametakiwa kufika mahakamani, hawajafika mahakamani. Wakili wao Paul Nyamodi akiweza kuelezea kwa nini